Beginning on July 1st, a new workplace justice visa that uses the subclass 408 visa in its own stream became available. The Migration Amendment, Workplace Justice Visa, Regulations 2024, were passed by the Australian government in order to address and lessen workplace exploitation and to guarantee that temporary migrants in Australia are treated fairly. The Workplace Justice Visa, a subclass 408 visa program, has been added to the migration regulations and essentially replaces the Assurance Protocol. In this video, we will go through the main points of the Workplace Justice Visa, requirements for eligibility, and effects on both employers and migrants. Purpose of the Workplace Justice Visa. This new visa program is an important step in protecting vulnerable temporary workers and tackling workplace exploitation. It helps people seeking justice by reducing their fear of having their visas revoked and by promoting the reporting of violations of labor rules. It is unclear how many applicants will really be ready to start such processes without any assurance of immigration help due to the requirement that the applicant have legally executed complaint proceedings prior to filing the visa application. Applicants who have been dissatisfied with the department's recent trigger-happy attitude to rejections across a wide range of visa categories will be especially concerned about this. Key features and certification requirements. With availability of extensions of up to 4 years, the Workplace Justice Visa permits temporary migrants who have been victims of industrial exploitation to stay in Australia for 6 to 12 months. Through the ability to work while engaging in actions aimed at obtaining justice, such as filing complaints against workplace exploitation or participating in legal procedures, this visa aids the affected persons. Candidates must have certification attesting to their experience of workplace exploitation from an authorized individual, organization, or government agency. This certification guarantees the validity of claims and is necessary for the application procedure. Consult the Migration Amendment Workplace Justice Visa Regulations 2024 for comprehensive details regarding the certification criteria. What are the key eligibility criteria? The following are the key eligibility criteria of the newly introduced Workplace Justice Visa. 1. It doesn't seem that an applicant has to have had a qualifying visa, yet some visas are prohibited, such as transit, special purpose, permanent, and visas for international relations. 2. In order to submit an application, candidates must already be engaged in workplace justice activities, such as filing complaints or participating in court cases involving exploitation. 3. Nothing suggests that workplace actions taken at employment before July 1, 2024 would not meet the requirements for a visa. 4. Secondary applicants may be added to an application, and applicants must belong to a class of individuals defined in a legislative instrument created by the minister that allows for future modifications. 5. There isn't a fee associated with submitting a legitimate visa application. 6. If the applicant was abroad when the visa was granted, they can still enter Australia even if the application has to be filed onshore. Impact on employers and migrants. The significance of defending the rights of migrant workers is shown by the Workplace Justice Visa, and it reaffirms the commitment of the Australian government to respecting human rights and ethical work practices. To stay out of legal challenges, employers need to follow ethical guidelines and employment rules. Currently seen as a pilot initiative, the Workplace Justice Stream will operate for 2 years under strict evaluation to determine its efficacy. Temporary migrant workers always have a barrier to reporting worker exploitation, and if they violate their work-related visa conditions, they risk having their visas terminated. Therefore, further safeguards were included to help temporary migrant workers who had experienced workplace exploitation from having their visas revoked. These latest adjustments were made in relation to the new rules established by the Migration Amendment Act 2024. That will be all in this video. Please share your opinions with us in the comments area. Don't forget to like, subscribe, and enable the notification bell to receive updates on job and immigration news. Thanks for watching.